Guys, I will be dictating 2 passages every day, one general and one legal. So subscribe to my channel for latest updates.
5 seconds. Before dealing with the virus of the impugned notification, it would be material to examine the relevant provisions of the Act. The Act has been passed to provide for minimum rates of wages in certain employments. Section 2B defines the appropriate government as meaning inter alia in relation to any scheduled employment carried on by or under the authority of the central government or in relation to a mine, the central government, and in relation to any other scheduled employment, the state government. It would thus appear that the legislature intended that the provisions of the Act may in due course be extended to mines, and so it has prescribed that in respect thereof the central government would be the appropriate government. Section 2E defines an employer as meaning inter alia any person who employs, whether directly or through another person, or whether on behalf of himself or any other person, one or more employees in any scheduled employment in respect of which minimum rates of wages have been fixed under this Act. Section 2G defines scheduled employment as meaning an employment specified in the schedule or any process of branch of work forming part of such employment. Section 3 authorizes the appropriate government to fix a minimum rates of wages in regard to the employments specified in parts 1 and 2 of the schedule respectively and prescribes the procedure in that behalf. Section 5 lays down the procedure for fixing and revising of minimum wages. Section 5(2) provides that after following the procedure prescribed by the said section, the appropriate government shall by notification in the official gazette fix or, as the case may be, revise the minimum rates of wages in respect of each scheduled employment, and unless such notification otherwise provides, it shall come into force on the expiry of 3 months from the date of its issue. There is only one more section which needs to be mentioned, that is Section 27, which empowers the appropriate government to add to either part of the schedule any employment in respect of which it is of opinion that minimum rates of wages should be fixed under this Act after following the procedure prescribed by it, and the section adds that after the notification is thus issued, the schedule shall in its application to the state be deemed to be amended accordingly. Para. It is thus clear that the whole scheme of the Act is intended to work in regard to the employments specified in Part 1 and Part 2 of the schedule, and the legislature has wisely left it to the appropriate government to decide to what employments the Act should be extended and in what areas. Section 5(2) empowers the appropriate government to fix or revise minimum wages in regard to any of the employments in the schedule to which the Act applies. This power can be exercised only if the employment in question is specified in the schedule and the Act is therefore applicable to it. Section 27 confers a wider power on the appropriate government, and in exercise of the said power, the appropriate government may add an employment to the schedule. The nature and extent of the said two powers are thus quite separate and distinct, and there can be no doubt that what can be done by the appropriate government in exercise of its power under Section 27 cannot be done by it in exercise of its power under Section 5(2). It is significant that the impugned notification has been issued by the Madhya Pradesh government by virtue of the powers under section 5(2) of the Act, which have been delegated to it by the President in exercise of his authority under Article 258 of the Constitution. The main argument urged by the learned counsel is that the impugned notification is ultra vires of section 5(2) because stone breaking and stone crushing operations in mines do not fall under any of the items in part 1 of the schedule. The dispute thus raised really lies within a very narrow compass. Does employment in stone breaking or in stone crushing operations carried on in mines specified in the impugned notification amount to employment in stone breaking or stone crushing, which is item 8 in part 1 of the schedule of the Act? The object and policy of the legislature appear on the face of the Act. The object of the Act is to prevent exploitation of the workers, and for that purpose it aims at fixation of minimum wages which the employers must pay. The legislature undoubtedly intended to apply the Act to those industries or localities in which, by reason of causes such as unorganized labor or absence of machinery for regulation of wages, and the wages paid to workers in the light of general level of wages and subsistence level inadequate.